Hey, everybody. My name is Andy Moore, and I'm the Director of Freedom of Information, Oklahoma. We are so excited for you to be here today for our July Lunch and Learn about the intersection of the Open Records Act and law enforcement, legal stuff. We chose this topic this month because, well, we did a bunch of topics. This one in particular, because I get a lot of emails and phone calls with questions from the public about this issue. What records are available? How do we get them? What happens when law enforcement says no? Because I think often we think about law enforcement as being the branch that would come in to help us get access to records when another branch refuses to uh, without authorization under the law. So we're going to talk about that today. My guest today, one is Katie Beth Gardner, who's been here before. Hello, Katie Beth. We are also going to be joined perhaps by Michael Ridgway, also an attorney here in Oklahoma. He's on the board of FOI Oklahoma. Michael is traveling today and is somewhat at the mercy of the airlines. And so his attendance, I suppose, is somewhat up in the air, if you will allow me that pun. All right, well, so we'll proceed anyway. Audience, if you are listening, if by some chance you got here and you don't know who FOI Oklahoma is, I'll tell you real quick. We are a nonprofit organization. We're a 501c3 based here in Oklahoma. We are Oklahoma's organization to champion and support and promote transparency in government and the First Amendment more broadly, right? So that includes freedom of the press, freedom of speech, all of those things. And we've been around since roughly 1990, really since the first kind of transparency laws were passed. And you would think that this kind of organization is necessary, right? That the law's on the books, everyone follows it, rah, transparency in government. Unfortunately, that is not the case. We do need groups like us and people like you there at home to help advocate, support, and promote this, and honestly, to hold the government accountable to ensure that if they're doing the people's work, that the people have access to the information that they need that is allowed to them under the law. Okay. If you have questions today as we go along, please feel free to drop them in the chat. I will keep an eye on that. We will have some time at the end to answer those. Although I guess if one is really pertinent to what we're talking about, we'll just address it right then, and we can go with that. Generally, these take no more than an hour. If we get done early, then we get done early. I just ate I had a wrap from Jimmy John's, if you're curious about the lunch portion of this, but I ate it before we got on here because no one wants to see the host eating a sandwich. But if you're at home, we can't see you. Please feel free to eat your sandwich. Okay, on with the topic at hand. Hello, Katie Beth. Thank you for being here again this month.
Of course. Thanks for having me.
Let's start, I think, at the top, right? So let's just lay the groundwork. What types of legal documents, and I will probably use legal and law enforcement somewhat interchangeably because that's probably how they're lumped in a lot of people's minds. But how are those records, what records are subject to Oklahoma's Open Records Act?
Yeah, that's a great question. So I think I would take it even a little bit broader of, in case any of the folks out there didn't see any of our previous panels, we're talking about the Oklahoma Open Records Act, which is the state's freedom of information law that allows any person access to government records. And a specific portion of that law deals with law enforcement records. So that's what we're talking about today. I'm going to share in the chat a link to kind of the specific portion of the Open Records Act that we're talking about today in case you want to read it or follow along with us. But if you go visit that link, it will specifically tell you what law enforcement records should be readily available for you to inspect, copy. That's things like mugshots or who's being booked into jail, arrest reports, what's happening with warrants in counties, radio logs from different calls that are going out, body camera footage. So it's a large group of records. And as you can kind of guess from what I've said, it's not just paper records, right? It's a lot of different things. Records is really broad. So it's really things that are within the custody and control of law enforcement agencies that relate to these kind of specific delineated things that are laid out in this law.
That's really helpful. I don't think I even have seen that list, at least on that website. That's extraordinarily helpful to kind of break it down there. Now, something I don't think we've talked about, maybe we have in previous lunch and learns, but we are today specifically speaking about the Oklahoma Open Records Act, which differs from other states, right? I guess all states have some sort of Open Records Act on the books, but the details of that does vary state to state.
Absolutely.
In Oklahoma, does it vary from county to county, city to city as well, or is it all at the state statutory level?
Yeah, so the law itself is a state law. It applies broadly to every level of government, all the way from the top, like the governor's office, all the way down to your local school board. But within the Open Records Act, there is a large amount of flexibility for things like how agencies are going to actually do the work of making these records available. So you'll see maybe the city of Oklahoma City, for example, has an online form that they make available for you to fill out if you would like records. There's a lot of flexibility in the law for how agencies want to carry these mandates out, as long as they're following the guidelines of, making records available during their regular business hours, making sure that somebody is always available to make records available to the public, things like that.
Sure. So my next question, and actually Jonita asked the same thing, is there a difference? Does it matter if the records are of a civil legal matter or if they're of a criminal legal matter? Certainly, obviously, like arrest records would be on the criminal side, other things would be on the civil side, but how does that break down?
Yeah, so within the Open Records Act itself doesn't necessarily make a distinction between whether something is like a civil record or a criminal record. Rather, the Open Records Act says all records of government agencies in Oklahoma are to be available to the public unless they meet a specific exemption that's laid out. Now, the section that specifically applies to law enforcement agencies works a little bit backwards because it takes that list of things that we talked about at the beginning and says that these are the records that are available to the public. And it says otherwise, you might have to meet a special balancing test or show a special interest to procure records from a law enforcement agency. So it works a little bit backwards, whereas every other part of the Open Records Act says, all of these records are open and public unless something specific applies.
Interesting. Okay. Michael just texted. He's on standby for a flight, so he should know something in a few minutes. So a question I get a lot is about arrest records specifically. Are all arrest records open or subject to the Open Records Act? Are there caveats for them? How does someone know, if you're looking for, I get a lot of calls of people looking for their own arrest records, trying to challenge it in somehow, or for a family member. Can anyone go to a police station, courthouse, and request those records?
Yes, absolutely. So the important thing is you need to know who has those records. So if you're, wanting to find records related to your arrest or the arrest of a friend or family member or just a random person that you read about and you're curious, you want to know some more, you need to know who that arresting agency was. Was it the Tulsa Police Department? Was it the Osage County Sheriff's Office? And you will be able to submit an open records request to them for usually what people say is things like, I would like, the arrest report. That can vary agency by agency of what they call it internally, what kind of documentation they actually produce. But the Open Records Act says specifically, you're entitled to know things like who was arrested, what's their name, what is some of their identifiable information, so that you can ensure that you're, looking at the right person. Why were they arrested? Like, what led up to this? What's a brief summary of the incident that happened? Those are some of the things that you're entitled to. So in a lot of places, like, if you put in a request with your local police department, maybe you'll just get the general report that they generate automatically anytime they make an arrest. Other places, they might have kind of more of a specific form for fulfilling this specific type of open records request to you. It just kind of depends on the agency.
Sure. So this is a question I think that I've had for a while. Let's say you get arrested in whatever town, or you're going to get a request a copy of that form. And you go in and you say, I'd like a copy of the arrest record for Andy Moore. And they come back and say, record does not exist. And you're like, well, I know it is because they call it an incident report, not an arrest record. Are they able to like deny it on a technicality, or like, do you have to request the exact right name of the document you're seeking in that kind of situation?
So in this situation, it can get really tricky. And this is why I recommend that people do some research beforehand to help make sure, because I'm sure what you really want is just to get the information as quickly as possible. And so if you can do a little bit of legwork beforehand, like for instance, calling the department and trying to talk to their public information officer or whoever fulfills their records request and saying, most of those folks can be very helpful. They can let you know, yes, we typically generate this type of report. And if not, you can always try to just include, language. What I like to do a lot of times is just copy and paste from the language of the Open Records Act, saying like, I want these specific things, and just say like, one related to Andy Moore, date of birth, this. Because usually the more information, if you can help meet that agency's kind of requirements or preferences, that's going to get you the information faster. Same if a lot of times I have had instances where I know, the incident report number. I know the date that this happened. I know the time that it happened. I might know that it was Officer Jones. Kind of anything that you can add into that can be really helpful for the agency, especially if it's somewhere in a large place like Oklahoma City or Tulsa, to get in there, find that information quickly and turn it over to you.
Yeah. I mean, I think we've all run into that with some government agency, right? This bureaucracy where you're talking to someone, you're like, I want this. And they're like, we don't have that. And you're like, I know you do. And so it helps to do a little bit of homework up front, so that you can go in and not bump your head against that frustration right there.
Exactly.
Another thing that we often see, I guess, in the news a lot is about police officer body cam footage, right? And there's always a very public discussion about if and when that will be released. What does the law say about that? Also knowing that like body cam footage is a relatively new thing as compared to when these laws were written. So what's the status of that?
Yeah, so the Open Records Act itself, specifically in the law enforcement section, does mention and has specific little subsections related to not only body camera footage, but dash camera footage, which can be helpful for agencies like Oklahoma Highway Patrol, who might just have car cams. So it specifically says that you are entitled to that body camera footage. There are some specific exceptions within that. For example, they are required to, redact or obscure out if that footage might show a dead body or somebody who has suffered a really great bodily injury. But specifically, it talks about it is very important for the public to have access to information about what is the type of physical force being used by law enforcement officers? How are they affecting arrests? What do these pursuits look like that they're doing in our neighborhoods? What are they doing when they are detaining people for an investigation? Getting access to this type of footage can be really helpful to ensure accountability and transparency. And the reason that we even have a lot of this in the first place is taxpayers are investing a significant amount of money in these programs. It is not cheap to outfit, every officer in your city or county with this technology. And we were sold that on the promise that it would increase transparency and accountability. So I encourage everybody to use that. That is something that your tax money has helped invest in for this specific reason, to help encourage transparency and accountability.
Yeah, that's right. While we're talking about video cameras, two other questions that come up about just security cameras. So not necessarily officer or dash cams, but like a security camera that you would have. First, what about on public property? So a security camera that's at a state agency building or like on a school. Um, are those subject to open records, and does it matter where they point? Like, for example, let's say it's a high school and out by the field house, right? They've got a security camera so no one steals their like football equipment, and the camera looks only at the field house and the school property versus one that might look and include part of across the street of private residences, right? Like if the field division. So I know that's like several questions in one, but there it is.
Yeah, so I would say yes, those could be considered records that would be available to you under the Open Records Act. But I wouldn't consider those like law enforcement records. I would just go through the regular Open Records Act provisions to get in that information.
Right.
And then I think you had a question too in there, Andy, about did you mention like security camera footage on like with a private entity?
Yeah, that was my next one. Yeah, it's like private. It's like I've got some little security cameras in my house that like are out there. Where's the line with that?
So I think the line with that is that, you can't just go up to your neighbor and say, like, I see you have a Ring doorbell. Like, I want access to that. It's a public record. It's not. That's that person's private property. But there can be instances where a record like that can be transformed into a public record. So, for example, several years ago, there was a very high profile criminal and civil incident that happened in Norman, Oklahoma, where a student athlete at the University of Oklahoma allegedly assaulted a woman. It was captured on a kind of store security camera of the sandwich shop that they were in. And so that's a private business, right? It was just a Pickleman's. It wasn't anything owned by the university, wasn't a cafeteria or anything like that, just a kind of a local business in the area. And that video was a public record and a law enforcement record specifically because it was a fact concerning that man's arrest and what led to kind of the criminal case in that matter. So you might see that a lot in cases where potentially criminal conduct is captured on some type of private security footage, that it could be transformed and become essentially a public record by coming into the custody of a law enforcement agency who's doing an investigation.
Yeah. Interesting. So like a very specific example that I think I got via email a while back is something happened at their house. And across the street is a school that has a security camera, and they know that or they think that it shows their house, right? Let's say it's a robbery. And they know that there's this camera that points at them. It's on school property. It's owned by the school. And they know it's on. Should they try to get the footage from the school, Or if the police have been involved, should they try to get it from the police? And what happens if they say no?
Yeah, I think that's a pretty specific question. So I think in that situation, I don't want to give any legal advice to that, but it sounds like, I would maybe, if I was potentially a victim of a crime and saw that, something was, I believed it could be captured on some type of video that belonged to the government or was in the public sphere. That's probably something I would try to make the officers who are performing the investigation aware of, to see if they can do that legwork for me and, collect evidence that could potentially be useful in this case. And if, they got access to the information, then absolutely it should be easier for you to then have access to that, see it, review it. But yes, I think that there could be like a situation where you could specifically go and try to get that as an open record from a public agency if they so happen to capture it. But I think that's also probably going to be really difficult with a lot of the technology limitations, where you're going to see that like that video will probably disappear really quickly, because frequently what you find is if it's not collected, immediately or within 48 or 72 hours, then those tapes just like roll right over each other. So unfortunately, sometimes a process like an Open Records Act request, which could take, a few days, might be a little too late for that.
Yeah, that's right. Yeah, you forget about that like overriding schedule that happens to those, which is why viewers, if you have a security camera, buy the biggest memory card you can, because you never know what's going to happen. All right. Well, when it comes to requesting records from law enforcement, I know 2 months ago, I think in one of our very first lunch and learns, we discussed how to submit an open records request. It might have also been last month, and we had some audio problems last month. So when it comes to requesting records from law enforcement, is there anything special that we need to do to help ensure that those get fulfilled?
So I would just say a little bit similarly to my earlier answer of, if if it's somebody who doesn't have a lot of information available online, a lot of these agencies will have, like I know, for example, the Tulsa Police Department has a whole page on, this is how we want you to make an Open Records Act request. And if you follow that, that will help you get your request fulfilled faster. So try and do a little bit of legwork to figure out the policies and procedures that that agency likes to use. And then just go ahead and submit your request. Like I said, a lot of them might have an online form. They might say, email your request to this email. They might give you a form to print out and mail off. But usually in that, there will always be a specific portion for you to describe the records that you're seeking. If you can, and if it's applicable, just copy the language out of the statute and, make it a little bit more specific. So put in any information that about like what time something happened, when it happened, where it happened, to help them locate that record faster. And then send it off. And if you don't hear anything, don't feel like, oh, I wonder like what happened to that. I guess they just denied it. Absolutely feel free to be, firm, polite, and persistent with them. Follow up, give them a phone call, create an email record of, I'm checking in on the status of my request. When will it be available? And hopefully that will get you some movement and ultimately get you the records that you want.
Yeah, that's great. When it comes to, I think, legal records, both civil and criminal, we often hear the term that records have been sealed, right? What does that really mean? What kinds of records can be sealed? Are there kinds that can't? And are records that are sealed, are they still subject to the Open Records Act?
Yeah, so I think that's a really good question. And specifically, like sealing a record is kind of a term of art, and it will refer specifically to, in a lot of cases, sealing court records. So where a judge has found that a specific test has been met, there's a specific interest in basically removing some type of record from the public record and making it private, or maybe making it, only subject to disclosure in very limited circumstances, like maybe just to the attorneys in that case. Normally what you will see is, instead of a record being sealed in that way, is that if you put in a records request, and the agency or public official believes that it's not a public record for whatever reason, they're just going to deny your request. But it's really important that you get them to tell you why, instead of just like, your request has been denied. It is their job as the government agency to tell you specifically why they denied that request. So they should give you a reason, like, 24A.7 says this thing, which means you're not entitled to it, so that you can then determine what your next steps are. Does this seem legitimate to me? Should I get a second opinion on this? Maybe there was a misunderstanding there and I can clarify. It is their burden as the government to tell you why they do not want to fulfill a request, because everything is presumed to be an open record in Oklahoma.
Yeah, that's very helpful. And just to clarify, because I think we're just so used to things being available online, right? And on OSCN, you can find all kinds of information about most folks in most counties, from marriage licenses and divorce filings to criminal stuff and all of that. But there is a difference, just to be clear, that something may be available under the Open Records Act. That does not imply that it is necessarily available online, right? In many ways, these laws like predated the modern internet, and so files may exist only in paper form, and they are thus not available online. Body cam footage, right, isn't all uploaded. That would be an enormous amount of storage required. And so if someone's looking for records and they look them up online and it says, like, document available at the court clerk's office, or it doesn't say anything, you have to just go down there and ask for it. It may still be available under the Open Records Act, even if it's not online.
Yeah, absolutely. That's a great point. Don't be discouraged if you see that. That's usually just kind of a county by county decision of what technology they have available to them. If you see that document available at the court clerk's office, or you see that there's a document, just call the court clerk and see if you can talk to them about it. Many of them are super helpful and will be happy to kind of just email something over to you, or maybe they want you to put in a formal request or something like that. But definitely call. You can always go in person. They can pull files for you. You're probably, unfortunately, not going to find a lot of this information just readily available online. You will be able to find things specifically in regards to kind of law enforcement records of, like, who does the government currently have in custody? Like, who is sitting in the Tulsa County Jail? You can go look that up right now online and see kind of a live who's in the jail, when did they come in, why are they there. But kind of outside of that, these incident reports aren't going to just be on a portal on a website for one of the agencies. You're going to have to put in a request for that. They'll gather that information for you and get it over to you.
Yeah. On a more personal level, long before I ever worked with FOI Oklahoma, I was a mental health therapist and did a lot of community mental health work. And it was often very helpful to us, working with clients, to be able to pull up, like, if someone no-shows their appointment, and that maybe they have some stuff pending, like they've got a warrant. You could quickly pull up the jail and see if they were currently incarcerated, to be like, oh, well, they're not here today because they're there. Okay, that doesn't count as a no-show. Also working with clients, it was helpful to pull up OSCN if they knew they had a court date coming up, they didn't know when it was, to be able to get that information quickly and easily without having to rely on calling someone and going through all of that. So I think there's very reasonable real world examples of where having access to public records is helpful in moving society forward and just keeping everything, everything going. So I want to get into, I have a couple of questions about when records requests are declined. And I'm going to preface that by saying, in my experience, and certainly let me know yours, but I think in my experience, most folks at most agencies want to be helpful, right? Like very few people I know like to tell people no because they are conflict avoidant and they don't want to get into that. They would love to be like, yep, here's the record. Okay. And sometimes it's a matter of like asking in the right way so that they can be more helpful to you, right? Like they want to say yes, they want to help you. It's just a matter of like figuring out exactly what it is you need so they can do it correctly within the bounds of their authority. Now, all that to say, on what grounds can law enforcement specifically decline or refuse to provide documents that are requested under the Open Records Act?
Yeah, so I think what generally would happen is when they get a request, they'll review it, and they'll have to decide, do I think that this is something that is, mentioned in the Open Records Act that we need to provide to people, or and is this just something that we want to provide? Some agencies will just hand over lots of information, and they're very transparent with the public about what are their policies and procedures, how are they carrying out their executive duties and functions, and how are they ensuring community safety. If you are denied, like I said, you should be getting kind of a specific reason, and you should be checking that against what the law enforcement statute says. A lot of times what you'll see happen is a law enforcement agency will feel like one of these things that are specifically listed, whatever you requested, maybe falls outside of that. So they just say like, sorry, we're not going to give you this. There is an interesting portion of the law enforcement records statute, which talks about, it doesn't say, that if a record is not mentioned here, that it can never be turned over or anything like that. Law enforcement agencies can be as transparent as they would like with you. But there's also an interesting provision that talks about what are the interests in the public having access to this specific record. And oftentimes in my requests that I make to law enforcement agencies, I will ask them, if they're going to deny me access to a record, that they need to tell me why, and why they think that like the privacy of that record outweighs my right to know, and to use it however I see fit, because that is something that you can use, if you decide like this is so important to me that I'm going to take it to court to see if I can enforce this record. That can be helpful information for you, to know why that agency specifically denied your request. They might say something like, I know the past few years, there's been a lot of investigation into what are these internal policies and procedures of law enforcement agencies. How are they conducting police chases? How are they carrying out no-knock raids? You might get a denial based on something where a law enforcement agency feels like, providing this information, making it publicly available is going to, cause us to lose a strategic advantage in our like law enforcement capabilities. So like making our playbook available would allow people who are trying to get around that a strategic advantage. So that's one that I kind of commonly hear. But if you get that denial, I encourage you, press them for that specific reason. And if you get it, okay, like you say it's this reason, but why don't you want to be transparent about this? Why is your interest in maintaining the privacy of this record more important than my right to know?
Yeah, that's such an important point, right? The law sets the minimum threshold for transparency. Like this is the absolute minimum you have to do. Agencies, law enforcement agencies, state agencies can certainly do more. And we've got examples around the country of states that do far more than what we do in Oklahoma. So you will often hear from us at FOI Oklahoma encouragement for people to follow not just the letter of the law, but the spirit of the law. And like, if you want to be transparent and actually win over the public's trust, that's what you should do, way more than what is necessarily required. none of us were raised to do the bare minimum, right? None of our moms would be thrilled with that. So let's do the right thing. A couple of questions in the chat or comments that are relevant to what we're talking about right now. Then we'll circle back and catch up on the other questions. But so two things that were related. One is, can an agency refuse to release body cam footage until an official investigation is complete? So like, can they refuse to release information if there's an ongoing investigation? And related to that, Ted Struley, who happens to be the president of FOI, asked, under the law, it says that audio and video recordings withheld as provided in this particular subparagraph shall be available for public inspection and copying before the conclusion of the investigation if the investigation lasts for an unreasonable amount of time. So the obvious question there is, how do we define unreasonable?
Yeah, so I think that is what a lot of lawyers like to say, going to be something that is very on a case by case basis. You're going to have to look at the specific facts of that incident. We do know a little bit about, so specifically the body cam and kind of dash cam footage of the Open Records Act is very specific in laying out its exceptions when they apply, for why a law enforcement agency could potentially not turn over footage that they would otherwise be required to. So if it's something where you kind of get the excuse of like there's an ongoing investigation or something like that, as soon as somebody is kind of criminally charged in that matter, the clock begins to run on that for the agency to make that information available to the public. So if you want, body camera footage of how this arrest for a robbery went down, as soon as Jane Smith is charged for that robbery, she goes to court and has her initial appearance with the judge. They're on the clock for 10 days. Following that, they have to make that footage available to you. There are kind of specific reasons that maybe the defense in that case, the prosecutor could ask the court for more time to kind of, hey, let's put a pause on this. There's a very specific reason why, this can't be made publicly available. But the presumption, there's a strong presumption of release in that situation. So that's kind of one important date to remember, or time frame to remember, is that kind of 10 days. If you have the case where, I think this is what is true in a lot of situations where, nobody has actually been charged yet. Maybe the district attorney or somebody like that says that they're investigating, law enforcement's still investigating. You have around 120 days from the date of that incident to put the law enforcement agency on the clock. And they really need to know what they're going to do kind of at the end of that period. Because at that point, you can then appeal to a court and ask for this information to be released. They can't just keep saying like, oh, we have an ongoing investigation. We don't know how long it's going to take. And then there's kind of a specific portion that of the law enforcement records section dealing with body camera that talks about law enforcement officers that become the subject of internal investigations. Sometimes that is where agencies can say, we don't want to provide this while we're doing our internal investigations and we'll get back to you. But the investigation can't last for an unreasonable amount of time. So I think in that instance, you would just have to specifically show why it's unreasonable, like whatever they're doing is. Maybe you look to the closure rate in other instances of similar misconduct. So if it's, let's say, a police shooting, let's look at other police shootings by this agency. How long did it take for them to release information? And I think that you can judge that against not only incidents where maybe they found officers at fault, but also officers not at fault, because often we'll see a lot of agencies being ready to be so transparent and make information available when it shows that they're doing their jobs well, and that's something that they want, commendation for, recognition for. That's what we hope for, and we often see in these cases where they think that it might kind of raise a question about how they're carrying out their duties, or that they have potential misconduct on their hands. They're less forthcoming with their transparency in that situation. So I think kind of using that fact-based of like, well, what is that exactly going on with this investigation? Like, do you have people left to interview? Are you waiting on a medical examiner's report? Or I don't understand why it's taking 9 weeks in this case, when in this case you released that information in 4 weeks. Trying to kind of have a dialogue about that can be helpful, for you to gather information of how am I going to be able to collect this, and if it's serious enough, present it down the line for some type of enforcement action. So like maybe going to a court and saying, I would like this information, I'm being denied it, and we need you, the judge, to make a decision about who's right here.
Yeah, that was my next thing I was going to ask is like, okay, so if it seems pretty clear or likely that an agency of some kind is drawing things out or refusing or trying to scuttle stuff, and just stall, right, for, whether it's 2 weeks or 2 years or 2 decades, an unreasonable amount of time, what do you do? And at the end of the day, I guess the answer is you got to find an attorney, right? And you may have to take it to court and let a judge decide on this. And in that process, right, like getting together again, doing your homework. So if you can find out the duration that it took for other records requests, something to give a benchmark of here's the average, and this is why this is way exceeded the average, to go from there. That sounds like pretty helpful. Any other guidance on what to do if you feel like they're dragging things out on you?
Yeah, so I think that you raised an important point, Andy. Your remedy under the law is to file a lawsuit to try and enforce your right to have a record and to get a judge to order that agency to turn the record over to you. But that doesn't have to be, your only option. I think, especially in this space, we see a lot of really great public advocacy about, people raising awareness of these things, calling attention to them. And sometimes that can be enough to put pressure on an agency to be more transparent, and realize, that like maybe all of the hoopla that we're putting these requesters through is raising more questions about our actions and how we handle this particular situation. And if we were just transparent with the public, then maybe we could actually start a dialogue about what actually happened, how we're taking steps to fix it, things like that. So I think especially in the space with law enforcement records and body cam and things of that nature, you do see that some of these agencies can be responsive to public pressure, or public attention to kind of your whatever's happening in your case. If you've kind of run up against, I've been emailing and calling, I've gone in person, and I just really can't get anywhere with this.
Yeah, it can be so frustrating. All right, well, we've got just a few minutes left. Let's run through some questions. First question is from Robert. Are 911 calls subject to the Open Records Act?
Yes, they are. And there are several kind of provisions of the law enforcement record section that makes mention to things like radio logs and calls dispatched, and things that talk about audio and video recordings attached to law enforcement. So yes, that is something that is an open record that you should have access to. It's something that kind of county by county, city by city, that's a common denial that I see. And often, if I'm able to kind of talk with the city or government official about why they don't want to turn this information over, why they think it doesn't apply to the Open Records Act, that we're able to get that resolved.
Sure. Great. Does the Open Records Act apply to officers' personal notes on a case?
So in this context, I guess it would depend on what you mean like by personal notes. Because there are kind of specific reports and information that you are entitled to. Like the Open Records Act doesn't really delve into all of the details. Maybe if those like personal notes were about the reason that that person was arrested, like maybe if it was like this person was, driving this type of car in this area late at night, like that could be a fact concerning their arrest. But I'm also thinking of this in the situation where I think frequently with a lot of the agencies like OSBI or people like that who do they generate reports and then they'll make notes in the margins. I think it depends on what those notes are really about, what they pertain to, as to whether they would fall within this section or not.
Sure. That's a good question. Kimberly, who asked this question, if you have specifics, let us know. Because when I read it, I thought of like clearly a report that's filled out as subject, but like if the officer, he or she is like me and like keeps a little notebook and like jotted down some notes in an investigation or something, and someone for whatever reason would be like, the officer wrote it down in his notebook but it's not in the report, but this is important information. If that kind of personal notebook, and then I assume like a personal diary would not be, because that's like a personal step beyond what they would be doing, notes written in the course of doing work, if that makes sense.
Yeah, I think if it's like, Officer Smith writing in her diary about like, man, had a really tough day today. Like it was really, really hard out there in the field. That's probably not going to fall into it. But I think if you're, taking notes about like the, person mentioned this and like, I found this suspicious, like that absolutely could fall under things like those are facts concerning that person's arrest, what happened during their detention, things like that.
Sure. Yeah. Regarding those 10-day time limits for providing open records, Marianne says that she had a local law enforcement agency that uses a 30-day time frame limit, not on criminal cases. It sounds like that's that agency's kind of de facto time frame. Does that sound like it's reasonable or within the law, or should Marianne have someone else look into that?
That's a really good question, Marianne. So the 10-day time frame that I referred to, just to be particular with this, applies specifically to if you have body camera footage that is not being made available because it pertains to some ongoing, criminal investigation or something like that. All other records are supposed to be available to you during regular business hours of that public agency. So if it's something that really you could walk into the, county clerk's office and they reach into a folder and put it out for you, they should be doing that. There is no time frame. So when these agencies say like, we will answer your request within 30 days, that is incorrect. It is supposed to be the amount of time that it takes for them to compile that request for you. And they also can't say like, well, I'm sorry, but like Jim Bob came in here yesterday and he requested like, a request that's going to take us 2 years. Like they have to get to your request and fulfill it if it's something that's going to take them 20 minutes. They are obligated legally to fulfill it in the time that is reasonable for them to do that without, in the case of law enforcement agencies, pulling every single officer from the field and their patrols to come into the office and fulfill records request. It's supposed to be a time that it would be reasonable for their records department to get that request out to you, whether that's 2 days, 8 days, 12 days. It kind of depends on your request, but they shouldn't be telling you, that we'll get back to you in 30 days.
Right. And that's a good point to remind folks that if you're requesting information, you can go in person and take pictures with your phone. You can bring your own copy machine. You can do that. So if the records are available and they're trying to say like, oh, we just don't have the personnel to do it, you're like, hand me the folder. That's all I need to do, right? I can come view it in person. Um, Next question is, I think, a follow up to Kimberly's question earlier about personal notes, but it could be separate. If a person was questioned by a detective and then on this witness, and then on the stand, the witness denied talking to the detective, I guess so. That's like my scenario where perhaps the detective took down notes about something, and there would be thus physical evidence that might contradict someone's testimony. I'm not an attorney, but I watched a lot of Law and Order when I was younger, and so it's just I read a lot of WebMD, but I'm not a doctor. Um, uh, any thoughts that you want to add on that before we move on?
No, I think that is, something that I would try to point out to if there's an attorney that is friendly to you with that, point that out to them to see if that's something that they can bring up on, cross-examination, which is where you get to ask that witness questions.
Right.
And even if, you're not able to like prove it with hard evidence, sometimes just the way that they ask those questions it can be like, oh, you didn't meet with Officer Jones
Right.
on this day at this time, really? Can kind of clue people in of like, that doesn't really sound legit. So I would try and just talk to the attorney in that situation.
Yeah. Good. Good advice from an attorney. Talk to an attorney. A question from Sandra Longcrier. Is there a state FOI law that is considered best practice? So I'm assuming, Sandra, it might mean one of two ways. One, is there anything that Oklahoma's laws are really great about that other states should take notice? Or the reverse of that, are there other states that you are aware of that have really good best practices when it comes to open records that we should take notice of?
Yeah, so I would say specifically about the Oklahoma Open Records Act, it's actually a pretty strong freedom of information law when you look at the laws nationally. Throughout the years, there are sometimes more and more carve outs that are being implemented. And you'll see that, it is 24A point whatever, and now it goes all the way to 32. And most of those are like random exemptions for like, we don't want to make public confidential wine shipment information. And you're like, what in the world? But generally speaking, we have a pretty strong freedom of information kind of scheme here. I think something that absolutely could be improved is, for one, the law enforcement records section. It's kind of silly to me that every record is presumed to be open and accessible because it's so important, right? It's how people participate in their government. It's how they ask questions. It's how they decide who to vote for their city councilor, who makes lots of decisions important to them on a really personal level. It seems silly that they kind of reverse all of that for the law enforcement section and say, like, you're entitled to these records, and then everything else, we're going to make you jump through some extra hoops. So I think anything that can be done to help make law enforcement agencies more transparent is really great. I think some other states also have kind of interesting schemes that are easier for people to navigate if their requests are denied. So a lot of states might have somebody like a public records advocate, or somebody who's specifically assigned to, that person's not a judge, but say I'm, Sally Smith, and my request to the health department was denied, and we're at an impasse. We can't resolve that between us, but I can't really, for whatever reason, I can't afford it. I don't have time to. I can't go to an attorney and take this thing to court and drag it out for a long time. A lot of states have people that you can kind of go to, like government public advocates, that will look and kind of re-examine that request and say, like, hey, health department, like, I think that they're right on this. You really need to get them that information, or at least give you kind of a second opinion of like, no, I'm sorry, I think this was rightfully denied. Like, you're welcome to ask a judge about it. That's kind of an interesting scheme to me because it allows for, I think, easier participation. Because I think it's quite the the jump to just go straight to court, especially if you don't have an attorney and might be representing yourself, to try and enforce a request if you just reach an impasse with that government agency. Some other places to have interesting provisions where they entitle you, they more clearly kind of define like what's an unreasonable time. They try and give helpful benchmarks of like, you are entitled to a request in 5 days or things like that. Some states have things where they say, you're entitled to a request in 30 days. And maybe that's not the best, because agencies will, if it's something they could answer tomorrow, just wait it out till the 30 days anyways. But we do see in some states there are provisions that kind of help give more guidelines about what is a reasonable time frame. That can be helpful when you have an agency that is dragging something out for potentially months, which is not uncommon here.
Yeah, that's exactly right. Well, I think we're about out of time for today. Katie Beth, thank you so much for being here today. We'll give Michael a hard time for being flying standby and missing out on this. But this has been really useful. I know to me, hopefully to all of our attendees. This has been recorded. And so once it does all the thing, I will upload it to our YouTube channel, and I'll put it on the FOI Oklahoma Facebook group and all of that stuff. It'll be on our website as well, in case anyone wants to come back and watch it later, which I know is a fun time. Friday night, some popcorn, watching discussions about open records. Man, I tell you what, that is a great date. All right, so don't tell my wife that. She will disagree. Everyone, if you are interested in supporting the work that FOI does, including lunch and learns like this, you can go to our website, which I just put in the chat, foioklahoma.org. You can go to /donate and leave us a donation. That would be tremendous. You can join and be a freedom fighter with us. That would be even better. And also, I think I mentioned this last month, but we are trying to do a big lift here. We are trying to create a database of as many open records requests as we can gather in Oklahoma, right? So whether you're requesting it from a law enforcement agency or a state agency or your city council or whatever, some states have a centralized hub where you can go in and see what other people have requested and just download those results rather than submitting another request to the agency. Oklahoma doesn't have that right now. So we're going to try to build it. So like, this is as grassroots as you get. If you submit a request you've submitted, you can upload the documents if they're in a digital format. I don't have the ability to come to your house and scan them yet. So if you can scan them for me, that would be great. And you can submit them. And then literally it comes to my email, and manually every week or so I go through and make sure all the files are in there and that everything makes sense. Try to check for anything that's wacky. But we've got a bunch of stuff in there right now from some of our board members that have been helpful, some other journalists. For all of you that are out there, please do that. This is a labor of love and of enormous public importance. And so we're super excited about it. You will likely get an email about it in the near future. We're just kind of now rolling it out officially. So okay, well, that concludes today's webinar. Come back next month. We're going to do it again. It'll be great. And we look forward to seeing you each month, Wednesday at noon, for our Lunch and Learns. Have a good week, everybody.